So welcome everybody. Keep getting food, but my name is David Wilkins. I'm the faculty director of the Center on the Legal Profession, and this is our weekly speaker series in which we bring some of the most interesting people from around the world, quite frankly, who are thinking about our profession and how it's changing and how it ought to change. And you're in for a real treat today. I've had the pleasure of knowing Jeff for a long time. He actually once was a real lawyer, so that's not everybody we bring here who critiques the legal profession was actually a real lawyer. He had a long and distinguished career, ending up as the general counsel of Great Lakes Chemical Corporation. But he's crossed over to the other side and now is a professor at Suffolk Law School and has been doing some of the most creative thinking and writing about how do we transition from a kind of traditional view of the legal profession to the new view, and what happens to things like legal reasoning and thinking like a lawyer or not thinking like a lawyer, and that's what he's going to talk to us about today. So without further ado, Jeff, we're really happy to have you here.
Thank you, David.
Thanks.
Full disclosure, I'm trying to sell a book. First of all, let me thank Nathan Cleveland, who's not here, and Hakeem for accepting my invitation to invite me. And I really appreciate being here at the center. First of all, I have admired David's work for so long. But one of the interesting synergies here is I was a corporate legal executive at two GE clones, Allied Signal and Great Lakes. And so I was basically trained and mentored in the law and leadership mold, of which Ben Heinemann was the pioneer. So that's another connection. And then the third connection is the center's mission to bridge academic theory and real practice. My joke, in fact, I think at about page 11 of the book, is I have the dubious distinction, I think, of being the leading scholar in the world on the overlap of venture capital and Kantian philosophy. There is one, and I'm the only one. I tend to the theoretical, I'm going to tend to the theoretical, I think, on account of the book, but I am perfectly happy to talk about the mundane as well, particularly when I'm done with my remarks. So let me begin with a preface, which is that my critique is not a criticism of thinking like a lawyer. Indeed, what we teach, particularly in the first year courses, is an enchanting, powerful way of thinking rationally and methodically. What legal reasoning is at its core, thinking like a lawyer, is a method for converting narrative from a very complex real world into a particular model, one that spits out legal consequences. And it works almost perfectly in the purest form of pure lawyering, which is litigation. In transactional and other lawyering work beyond litigation, however, the weapon of legal reasoning, and the one that I try to teach so rigorously to my 1L students, and tell them ignore this talk when you take your exam, is that the metaphor may not be appropriate. What I wanted to show in the book was how this powerful reasoning method contains the seeds by which lawyers, and particularly non-litigating lawyers, can go astray. Now, I was lucky enough to come here a couple of weeks ago to listen to Richard Susskind, and Richard obviously is a futurist who writes, I'm not sure what futurists are, I would like to be one, but he writes compellingly about the professions generally and lawyering specifically. Like Richard, I am interested in the relationship of minds and machines. Richard's thesis, and it's a scary one, is that this is the increasingly capable machine who can replace you. It seems to me, in fact, I said to Richard just before his talk that I wasn't sure if what he was saying was either profound or trivial. That is, it seems obvious to me that machines will indeed replace just about everything that they are capable of replacing. But the statement that machines will replace whatever they can replace still begs the question, what are they capable of replacing? Hence, my inquiry is not into the reasoning machine that will replace you, but into the reasoning thing that is you. And my answer is that there is something in you at the heart of how you think like a lawyer that at least at present, a machine can't do. My little black holes. So, the book is about drilling down to that something and then discussing its consequences. And this is the point at which I need to issue a disclaimer. My naive conception of lawyers froze into place as a 12-year-old when I read the play Inherit the Wind and so much admired the Clarence Darrow character's cross-examination of the William Jennings Bryan character at the Scopes trial. And I have to say, nothing about that naive conception changed, even when I was in law school. I was a history major. I knew nothing about business. I knew nothing about accounting. And when I got out of law school, I was not crazy about blood. So I wasn't going to be a tort lawyer. But I joined a big firm fresh out of school, and it was as a business litigator. And I spent 10 years of that, from 1979 to 1989, all of the time coming to terms with the fact that I hated being a litigator. My partners in the big firm in Detroit were accommodating. I switched over one weekend, cold turkey, to corporate, not even knowing what it was. But for the next 16 years, as David has said, I was a business lawyer and a business executive, first in a law firm, then at two large businesses. And I learned pretty quickly in that environment that you could be right legally and wrong, so wrong, in every other respect. For example, you file a lawsuit for your public company client, I'm not saying I ever did this, against the seller in an acquisition that doesn't work out, claiming breaches of the reps and warranties, and maybe even there was some fraud. You are dead right as a lawyer. It is a knockdown case. You got it. But the day you file the complaint, your stock drops 3 points, because what your finally drafted complaint is telling the world is that you really don't know how to do mergers and acquisitions due diligence. Another example. Sarbanes-Oxley was the United States Congress's direct response to the corporate governance scandals of the early 2000s, Enron, WorldCom, Tyco, and so on, the Dodd-Frank of its era. I was the general counsel of Great Lakes, a public company, New York Stock Exchange company, at the time in the early 2000s, and had to lead our compliance with Sarbanes, the new New York Stock Exchange listing rules. So let me read a bit from the preface of the book about that experience. One of the inanities, in my humble opinion, of Sarbanes-Oxley I had to manage was the required designation of one or more board members as what were known as audit committee financial experts. Imagine the reaction of a well-to-do CPA or former CFO being trotted out publicly as the board member assigned to be the point person for discovering any financial shenanigans of the Enron variety. It wasn't that they refused to be so designated. It was more misery loves company. Hence the reaction was, if I'm going to be so designated, I want Joe to be designated too, so I'm not out there exposed all by myself. Well, Joe had been a CEO, but not a financial person, even though the CFO reported to him. And that was the loophole we used to designate Joe and almost everybody else on the board as an audit committee financial expert. At some point, it dawned on me how tenuous the relationship was between the presumed objective of the statute and the regulations and the hand-holding and other wasted time I was spending to get all this done. What you really wanted in a board member was the corporate rights stuff: intellectual independence, commitment, wisdom, and the courage to make tough calls. Some prophylactic rules, like barring directors with direct conflicting financial interests or with family ties to management, made sense as a negative assurance. But from the standpoint of positive assurance, there was simply no way to articulate rules of law, whether by legislation, regulation, or case decision, that captured the essence of the corporate rights stuff. There might well be a norm against which you would measure it, but it was going to be social or moral and not legal. So, the possibility of that disconnect between the rules and desired outcomes that triggered the 13 years or so that I've spent as an academic, thinking about and writing about rules, decisions, the overlap of legal and business judgment, and now thinking like a lawyer. So, the first part of the book, just remember, it's a book. As an aside, it's an expensive book. There are no stacks of books here for you to buy because they are ungodly expensive, and I'm just hoping at some point the publisher puts out a paperback. But you can get a relatively cheaper Kindle version. But in any event, the first part of the book is about drilling down to the thing that is non-machine-like in thinking like a lawyer. That is, of developing legal theories on behalf of one's clients. And so what do I mean by pure lawyering? The core of thinking like a lawyer. And this is it. There is a deductive core to legal reasoning, a basic if-then syllogism that underlies all the other aspects of thinking like a lawyer. That is, the analogic aspects, the inductive aspects, all of the thinking like a lawyer boils down to this syllogism. If P, then Q. P is true. If P is true, we have to conclude Q. That is, do the antecedent conditions P exist from which the legal conclusion Q must necessarily flow? If, as a lawyer, you can persuade a judge that that's the case, it is game over. The debate may well be, as we'll talk about, which syllogism is the one to apply. But if you can make that argument, it's game over. And putting together those if P then Q statements is how we construct a legal theory. Let me use the facts of a chestnut case in contract law to show how we construct opposing theories in that mode. It is World War II era Greece. D, I'm going to call it D, has money in the US but badly needs drachmas. So D signs an agreement saying she owes P $2,000 and P in return advances her 500,000 drachmas. Except that everyone knows that 500,000 drachmas in World War II Greece are only worth 25 bucks. Here's the base syllogism under which the court, in roughly 1946 or 1947, actually decided the case. If there's a bargain, then there's a contract. They made a bargain. Therefore, there's a contract. And that's it. What the algorithm doesn't include is an inquiry into the equivalence of the values being exchanged, as long as there's a bargain. It's known in contract law as the equivalence of consideration doctrine. And we use the case to show that courts generally don't second guess the value of a deal as between the parties as long as there was a bargain. Now, to give my students at Suffolk credit, some of them asked me a very, very good question about another possibly applicable theory, even though it was never addressed in the case. And of course, my answer was, this was a case in 1947. Unconscionability really came into play with the UCC, which wasn't until the 1950s. So the syllogism and the theory would run something like this. If an interaction is exploitive, then a court ought to decline to enforce it. The circumstances here are exploitive, therefore there is no enforcement. And we call this unconscionability doctrine. And this is typical, not just of this problem, but of many, many, indeed I'd say most, lawyering problems. The facts allow the lawyers to argue distinct and contradictory theories because the facts are mixed enough to support either if P then Q syllogism. Bargain theory, right, if you're the plaintiff, unconscionability theory if you are the defendant, and of course the debate is going to be normatively which theory is better. But again, if you can lock yourself into one or the other, it's game over because it's syllogistic. Now, point 2. What was the particular inspiration that caused my student, uncoached by me, to see an unconscionability problem rather than merely a bargain problem in those facts? That is, that particularly non-machine-like aspect of reasoning, it's appropriate to talk about it here at Harvard, is called abductive. And let me be clear in the terminology. Deductive reasoning is the process by which we must infer that a conclusion is true if the premises are true. That's logic. Inductive reasoning is the process by which we infer a conclusion from certain premises, but the truth of the premises don't necessarily guarantee the truth of the conclusion. That is, the premises are based on observations of past events. The conclusion is a generalization or a prediction about the future we infer from those particular events. Laws of science are the product of inductive reasoning. The Holmesian prediction of outcomes is the product of inductive reasoning. Abductive reasoning, in contrast to those two forms of reasoning, is that ability to see a mess of circumstances and infer a possible pattern to it that turns into a hypothesis. That is, even before I get to the deductive part or the inductive part, I have to see the pattern in the facts and conclude there is a deductive or inductive rule that's going to help explain it. Right? That's where it is. Right? That's the game. When we give law school exams everywhere and we bake in issue spotting, we are testing our students' abductive capabilities. In short, abductive reasoning is a leap. We pull a pattern out of our mental inventory of all the possible patterns in the universe, and we apply it to a new problem. Now, one of my favorite examples in the history of science is the case of the scientist, the chemist, Auguste Kekule. Chemical bonds were thought to be linear. One night he had a dream. He had a dream about a ring of fire. He woke up with the inspiration that perhaps the bonds in benzene weren't linear at all. And that was his theory, the ring. Let me read a little bit from the book about this. We have now arrived at the thing about thinking like a lawyer that is both hardest to do and hardest to explain. The legal philosopher Susan Hack described the literature on this aspect of legal argument as, quote, luxuriant, to say the least, a steamy, tangled jungle in which it would be easy to get hopelessly lost. Harvard professor Scott Brewer created a taxonomy of approaches to this aspect of thinking. One category he used is mysticism. That is, abductive reasoning is a rational force that is either or finds its source in spiritual acts. And for better or for worse, in that taxonomy, I am an unrepentant mystic. It's because I see no way around the magic in it, or the mystery in it. The leap from problem to avenue of solution we're talking about could also be characterized by words like inspiration, imagination, creativity. What's going on is the application of professional judgment. What makes explanation so hard, what makes teaching so hard here, is that we can give practical tips for helping with that judgment, but you cannot state a rule for it. And the reason is that there is no rule for the application of a rule. In order to apply a rule or an algorithm or a model to a particular situation, we have that abductive moment of choosing the rule. If there's a rule for the abductive moment, we would have to select that rule. And in order, again, to determine what circumstances fit within that rule, we'd have to set another rule. You need another rule for the second order determination, and it goes all the way down. It is an infinite regress. There is no final answer for the selection of the rule, period. And so the human or non-algorithmic aspect of pure lawyering is the setting of the problem into a legal theory. Neither deduction nor inductive reasoning dictates that problem solving. And so what is the potential? What is the potential untoward consequence of that non-algorithmic human element of problem setting? Let me read a little bit abstracted from the book. Legal reasoning is a subset of reasoning generally. It is a thinking process by which we make sense of things. One kind of reasoned sense-making is descriptive. That theory-making shows up in matters as sophisticated as quantum mechanics or as mundane as figuring out why the car won't start. Another kind of reasoned sense-making is normative. It shows up in matters as impenetrable as religious salvation or as ordinary as deciding whether to let one's child stay home from school. Kant's critique of pure reason, with all due respect to Chief Justice Roberts, isn't all that hard to grasp. When we use reason to know things, as in science, it's good. Reason is benign and productive when applied empirically for the purpose of scientific knowledge. Reason is the source of theoretical descriptive knowledge if applied to experience or possible experience. Well, what about reasoning to normative conclusions? Well, that can be okay as well. In the moral or normative sphere, it might well be benign and helpful in getting to correct answers for practical questions of what to do. And indeed, the example par excellence is Kant's own categorical imperative. Act in a way that you would legislate for your action when deciding what to do. Your rule would be a universal law. In other words, morally correct decisions apply universally and categorically. It's an Enlightenment philosopher's recasting of do unto others. It's also the precursor to Rawls' veil of ignorance, by the way, under which you decide what is objectively just by putting aside what you know about yourself, your own proclivities, and your own desires. But there is a third aspect to the critique of reason, and it has to do with the resemblance of theorizing about what we can know to be true on one hand, and theorizing about what we would like to be true on the other. There are certainly ideas in which we can believe rationally, but conflating knowledge and belief, both of which can be the products of reason, can lead to illusions of knowledge. And in Kant's estimation, the worst of these conflations of belief and knowledge occurred when people were certain rather than humble in their assessments, in their own assessments of their own moral conclusions. In the extreme, the moral advocate persuades himself so thoroughly of his own virtue and rectitude as to become a moral dogmatist or fanatic. Now, the appearance of moral certainty and even a little fanaticism is an asset to an advocate, to a lawyer who is constructing the logical chain that would lead to a favorable result. And indeed, there is a permissible doublethink going on, in which everyone knows that the lawyer is a hired gun, earning a living by employing the methods of pure lawyering to fit the facts into legal theories that just happen to benefit the advocate's client or cause. And indeed, the most effective rhetoric style in front of a judge or jury is to encourage the willing suspension of disbelief, as in all fiction. We are transported, listening to the advocate, from the real world in which the desired outcome is merely one that ought to occur, to a hypothetical world in which the outcome must occur because the deductive logic of the law requires it. In short, when we reason, we don't automatically separate out descriptive or explanatory reasoning from normative reasoning, nor is there anything about reasoning that automatically confines it to what we really do know or are capable of knowing as opposed to that which we merely believe. My position is that what we know about the law is usually pretty trivial. Any debate about the law in any serious case is really about what it ought to be as applied to this particular circumstance. But even for someone like me, convinced there is no God-given natural law, one for whom all law is human-given or positive, it's hard not to conceive of law, the law, as having a corpus, a body, corpus juris secundum, a mind-independent reality. It's a thing out there. And even having a subjective agency like God that supports routine metaphoric sentences like the law demands, the law requires, the law dictates. The lawyer's setting of a problem into a theory of what the law demands or requires is normative, whether or not it is dressed up in the descriptive clothing that advocacy requires. So, what are the consequences of that uneasy resemblance of theorizing about what we can know to be true on one hand in short knowledge, and theorizing about what we would like to believe to be true in short belief on the others. And the back half of the book is indeed the critique of pure lawyering, and my suggestion that it can lead to illusions of certainty and truth, that what I believe morally, what I can argue, is more than just what I believe, but it is objectively true. Cynical and instrumental use of the law, I'll talk about that in a minute. Inappropriate game playing, where I don't think about the rules, I just lawyer with the rules. What I think is often an unhelpful and even inappropriate focus on blame rather than causation. For example, the fixation with perp walks as an answer to things like financial bubbles. Mental gridlock, the dilemma of the two-handed lawyer. This is when you reach the end of what rationality can do for you and you just have to decide. In other words, there is a cliff in front of you. You have just analyzed the crap out of it. But now you have to commit to either jumping or not. I don't think rationality gets you over the cliff. And then finally, self-deception, using your own power of persuasion to delude yourself. What I'd like to do is read a little from those discussions to give you a sense of the back end of the book. Here. The consequences of pure lawyering are, in a way, opposite sides of the same coin. How lawyers might come to think of the agglomeration of rules that make up the law. The first might be a cynical acceptance of the amorality of pure lawyering as an end in itself. For lawyers who think like this, pure lawyering creates nothing but the result one wants. What is true or real is nothing more than the result one gets. I have a vivid recollection of when, as a young lawyer and father, I was having dinner at a Chinese restaurant with several of my wife's extended family, including a father and his sons, all of whom were solo practice lawyers. I don't recall the precise subject, but it was something like the merits of a lawsuit in which the plaintiff dove off of a diving board into a partially filled swimming pool and then sued the pool owner and manufacturer on the theory that they had negligently failed to warn. And the gist of their attitude was something like, hey, if you can get a court or jury to buy it, it's fair game. And I think I choked on my Mongolian beef, sputtering how outrageous I thought that was. When you believe this, you make it sound like a game, you make it sound like a game, and it's not. Yes, pure lawyering is amoral itself, but that doesn't mean that you can't find standards somewhere. Be less cynical. A second possible consequence of pure lawyering is at the opposite end of the cynicism continuum, an often unreflective and good-hearted willingness to accept that pure lawyering can lead to truth. Here, there is no distinguishing between empirical and normative theory making, at least in terms of the truth value of what comes out of the pure lawyering process. I teach contract law. That includes the doctrine of promissory estoppel. One of the elements of promissory estoppel is a determination that injustice would result if a relied upon broken promise is not fulfilled. Now, call me cynical. But if you really believe there is objective justice to be found when two parties are using the tools of pure lawyering to squabble over a broken promise, you credit the law with a reality and a moral sense I don't think it deserves. Be less naive. There is a middle ground in which the lesson is to understand the pure lawyering process for the amoral and non-constitutive thing it is, but not to accept that as the end of the story. I am as willing as the next person to cherish moral and ethical vastness, justice, and majesty. If there's justice and majesty, it's because of the just and majestic things you seek with the lawyering, and not arising from the lawyering itself. So, here's a question. A contract is often a set of if-then statements that allocate future risk. There's a contract. It's an asset purchase agreement. If the P condition occurs, you are obliged to do Q. When you look at a contract, particularly a complex one like this asset purchase agreement, does that construct of rules create a model of something else, namely the deal, or is the contract, here's the deal, or is the contract the deal? Let me read a little bit about this. Like the activity of pure lawyering, games and models are thick constructions of rules. Like pure lawyering, playing or using them is a matter of rule application, either to win the games or to simplify the subjects being modeled. Are the following games or models? Financial statements prepared in accordance with generally accepted accounting principles, business acquisition agreements. Is one's lawyering a matter of playing a game, making a model, both or neither? If both, is one more real and does it have more thingness than the other? And what difference does it make in practice? My lengthy illustration at this point in the book is the complex and arcane structure of financial accounting and reporting, and the importance, if you are a lawyer in that milieu, of distinguishing between modeling and game playing. The construct of rules themselves do not provide the meaning to be taken from them. Again, from the book. Douglas Hofstadter of Gödel-Escher-Bach fame observed of human brains what is true in spades for effective lawyers. Their main business, quote, their main business is to take a complex situation and to put one's finger on what matters in it, to distill from an initial welter of sensations and ideas what a situation is really all about, to spot the gist. My thesis is simply that in addition to the process of pure lawyering, there are other ways of making sense of what is and what ought to be, and the possibility of error exists when they are inappropriately applied. It would be easier to spot the gist, as between games and models, if there were an algorithm or even a good rule of thumb for knowing which would do a better job of understanding a problem. The real world does not work that way. There is no rule for the application of a rule. Finally, a conclusion. The point of all of this is occasionally to step back and be a little meta about thinking like a lawyer. Because thinking like a lawyer can take you to some places that you really don't want to go. So let me conclude the presentation with some words on that theme from the last chapter. It ought to be clear by now that I have a reasoned skepticism about our ability to navigate through life on a wholly reasoned and rational basis. Sometimes being wise means understanding we just have to conclude, to decide, to act, to pay our money and take our chances. I recognize fully the abstraction of much of what I've said here, but I've wanted to counter the underlying rational, objective, and scientific underpinnings of much of the professional mindset. We can figure it all out and control it if we just think hard enough. My life as a lawyer has been too rewarding intellectually and otherwise to denigrate the orderliness and rigor of thinking like a lawyer. The essence of the lawyer's contribution to a business decision is the processing of knowledge under some coherent theory. The lawyer can create a theory of success, a theory of risk, a theory of liability, a theory of failure. But our legal analysis is but another rational path through a complex world. I am firmly convinced that great lawyers in the mundane milieu of making money bring something more than keen analytical skills to the table. They bring some kind of wisdom, a metaphorical creativity that transcends disciplinary boundaries, both within the law and without. Beyond that, even non-legal rationality has its limits. Creating and innovating products and solutions in the real world turn out not to be something that we can model in any form of decision theory, simplified or complex. Those problems invoke decisions. They are problems of action, of what to do next. They are not solely problems of knowledge or reason. In short, out there in the real world, when you aren't a litigator, these are the reasons, or some of the reasons, for unlearning just a bit how to think like a lawyer. So, again, I want to thank David so much, and Nathan and Hakeem for inviting me here. I hope I've interested you in reading the book. As I said, the hardcover right now is in library pricing. I do not claim to understand price elasticities and inelasticities in the publishing business. There is a reasonably priced ebook, and I just hope that enough people buy what's out there to have a paperback come out. But thank you very much. As I said, I'm willing to talk about the ethereal and the mundane. Yeah, David.
So, really interesting. So, here's what I want you to do, Jeff. I want you to, you could say that much of what you said could have been said, and actually was said by Jerome Frank in 1930, okay? What did he call the law? Existential mysticism or something like that, right? So legal realism created this challenge, right? Once we moved from legal formalism to legal realism, we now had to deal with this challenge. And then there's been a bunch of responses to it. And I guess I'd like you to locate you in response to the responses. So let me just give you a few of them.
Okay.
Critical legal studies. It's about politics and power. And that's what determines how the law works. And it's all about politics and power. Second, Abe Shea's legal process, okay? So actually the solution is to agree to a set of process-based understandings from which we will then at least confine the parameters of the acceptable. Dworkin. So this is Dworkin.
Oh,
so
Dworkin.
like coherence theory, right?
Yes.
Some idea that actually what you do is you look for the best possible explanation. Okay, you know Dworkin, right? And the last one is kind of where I think you are, but I'd be curious if I've read you right or wrong. Some kind of professional community idea. That there's something called legal judgment that lawyers have that comes from living in some kind of professional community, and that it's that judgment that actually in the end is what saves us from the abyss. And if that's it, then I want to know what that says about legal education and what we should be teaching people if it's not teaching people to think like Delaware. So anyway, tell me what you
Well,
think.
let me start from the back end. I have never suggested that we shouldn't teach people how to think like lawyers.
Yeah, no, I agree.
Right. I mean, you riff on it, you go meta on it, but I like to think I'm one of the more rigorous teachers of thinking like a lawyer. I had a bunch of students when I did this last week at Suffolk, and my 1Ls were sitting there, and I said, please don't listen to anything I'm saying. Parse, 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 parse. Your question is, so I have probably addressed somewhere, the book, Routledge only gave me 85,000 words, and trust me, I'm not sure it would be readable, but I probably have addressed where I stand in relation to each of those somewhere over the last 13 years. And I think the distinction between me and all of them is my incorporation of, again, the Kantian notion of reason, and what your mind does, and the fact that your reason can either apply to what we are capable of knowing and creating good science. It can maybe, because I'm not sure, I was more enthralled with the categorical imperative earlier in my academic career, but reason might be able to help us reflect on the right thing to do. But what worries me the most is what Kant called transcendental illusion, which is allowing your reason, which doesn't distinguish between that which is real and that which isn't real, to let you think, or to cause you to think, that what isn't real, or what is normative, is not just what you believe is right, but is true. What is true. And there's some aspect to all of that. So what I would say is, even though legal realists, right, even though legal realists downplay the corpus, I still think the metaphor is awfully powerful. And I think that it is really difficult to be a lawyer, to be a practicing lawyer, to practice with those rules and not think of it as a corpus. And what I think that tends to do is it tends to cause lawyers to believe that their arguments, that the process, the regulative process of reasoning, as Kant would call it, as creating constitutive knowledge as opposed simply getting you to a place. right? Again, it's that conflation of truth and belief that I worry about. So, interestingly, I am pretty sympathetic to aspects of critical theory. I remember reading the first several pages of Nomos and Narrative and thinking, this is Kabbalistic. This is what I believe about, very close to what I believe about what happens when human beings try to take something godlike and make it human, right? At some point, it coalesces into power, right? It coalesces into power. And so the idea that there is a limit to reason, right? And again, in the book, I talk a lot about the French existentialists, the European existentialists, that deciding something, getting to that cliff, right? And as a lawyer, I can have 8 arguments for jumping, 8 arguments for not jumping, but this is the crit in me. The crit in me says you can never figure it out rationally, whether to jump or not. That is a question of acting, right? And so, and then Dworkin. Dworkin to me is the ultimate in the creation of, or the conflation of, the is and not, right? Dworkin is the ultimate in, if I can come up with a reasoned, coherent structure of that corpus, I can locate the right answer to any legal problem, to which my response is actually not printable if I'm going to, right? But it's, yes. I just don't believe it. Yeah, Eric.
I'm wondering if, by the way, first of all, it's quite an ingenious structure you have. I really appreciate it.
Thanks.
Your talk. But I wonder if you're making the same sort of jump, because half of what you're saying is a description of what lawyers do, and then you seem to jump from that to lawyers should focus more on this mystical and less on the rational. And that entails, and maybe I'm misreading it, but that entails how do you do that? And this is where I think, for me, it breaks down. I don't think that you just invent where you want to go. I think, and we've talked about this, I think that it's closer to discovery than invention. You have to have, as a thinking person, you have to have some, as you said, mind-independent idea, whether it's normative or factual, that you are trying to approximate. If you, Scanlon gives the example, I think, of someone who has absolutely none of that, how do you act then? You don't just jump off the cliff. There's no basis for doing either of them. Right? So you have to assume that there's some truth. Now, I think it's a big mistake and a common one to conflate thinking there is a truth or trying to follow or find the truth with being certain that you're right.
And I think you wrote an article about that.
Yeah, so I don't think, that's right, I don't think that you have to be so hard on the idea that there is a truth, which is how we get to the normative. I think that just like scientific method, until it's proven false, this is a provisional view.
What I say in the book, in fact, and again, the talk, I'm obliged to boil 85,000 words of manuscript down to about 4,000 words that I can speak in half an hour, is, I'm sure, I say in there, I am not denying truth. I'm just trying to be very, very humble when I assert it. And indeed, that seems to me to be, in today's political environment, today's social environment, just a modicum more humility and modesty about what people are so damn sure they believe normatively seems to me to go a long way. And indeed, as a transactional lawyer, as opposed to a litigator, and I have to say, there's a continuum from you're a litigator for great causes, right? You're a litigator for great causes. I mean, I think I say somewhere in the book, the process of pure lawyering is the same if you're Thurgood Marshall arguing Brown versus Board of Education, or if you're a patent troll. I mean, the process of taking narrative and pushing it into those algorithms is the same. But if you move, and so again, as an advocate, I want to dress up what I want normatively in descriptive clothing. It's so much more effective to argue not that the law should be, but the law is, right? And so whether I'm a legal realist, or a formalist, or a crit, when I make that argument, I need to invoke that corpus, that something, that there's actually a mind-independent author that says, this is what the answer is, even though I'm skeptical, right? This is what happens to Kantians, by the way. We don't really believe, I mean, we have to walk this line between certainty, certainty and skepticism. I mean, it's why there's so few Kantians, I think, because you never really get to the end question. That's the whole point. And then the last point is, when you are trying to make a deal, being right ain't all it's cracked up to be, right? And there is an obligatory, again, somebody who's affiliated, David Katz from Wachtell Lipton. I did a deal with David once. David was on the other side of the table. And David, to me, and I told him this, was the exemplar of somebody who would sit there and try to process what the other side needed, right? And to me, that is not rational in the following sense. It is affective, right? You have to want to do that. You have to want to understand what the other side wants to then instrumentally get there and figure out how to make a deal. And I've told him, I will never forget sitting at a table in Wilmington, Delaware, with David on the other side, thinking, damn, that's really good, right? But it's not thinking like a lawyer. At least is the way we teach it. Why?
Jeff, I hope you'll forgive me for trespassing back into property for a second, because it's been a while since I dealt with this. But let me give you an illustration and ask you to sort of put it into the context that you're offering. To think back to first-year property, where we talk about landlord-tenant law, and the idea of constructive eviction is a fiction itself. It says that somebody's effectively been dispossessed because the heat's been turned off and all of that. But that doctrine had limits in terms of substantial justice because people had to leave the tenancy in order to fit the doctrine. Somebody, and I don't know who, a right clerk or some student or somebody came up with the idea and said, wait a minute, why don't we say it's an implied warranty of habitability? Then you don't have to leave, right? Now, that seems to me an exercise of the use of legal reasoning in the interest of manifest justice. And what I'm asking, is that an example of what you call abductive reasoning in order to get there? And if it is, how do we teach that to our students, except to say, just observe the fact that somebody figured out the earth goes around the sun rather than the other way around. There's a leap in the mental form.
And again, what I said was, you can model it. There is no rule for the application of rule. I do not know how to teach abduction. I don't know. I mean, my wife is sitting here. I am a terrible punster, right? And I don't know how they come to me, right? I don't know how they come to me, but the pun is just there, and that's another question, issue entirely, which is the pun comes out. And I think puns are abductive, right? Puns and jokes, humor tends to be abductive. You take two things that haven't been put together before, right? AI, the articles on AI say it's going to be a long time before AI makes a joke, right? Because that really is, and when it does, I'll agree, Turing test. But there's something else about what you said that goes back to what David asked, which is why I'm not a legal realist. Because I want to account for the desire, what causes people to want the doctrine to be coherent, right? Because what you've just said, a legal realist would say, screw it, who cares about all this doctrine? I should just do what I want to do because it's right. But what you've just described is this rational process of trying to fit it in to a set of previously existing rules so that it's justified by its coherence, not just by its outcome. And I don't think a legal realist cares about that. But I care about trying to account for why people care about that, and that strikes me as a product of our, again, it's the Kantian notion, our teleology, our desire to see form and purpose in things, as abstract as the law, as something that you have to make fit, right? Like the implied warranty of habitability, right? I can't just say, by dictate, right?
Well, you say, Jeff, let me just follow that up. If you agree that it's a novel application of a coherent theory, your thesis is that you still need a coherent theory in order to get to an end state. You can't just say, I want this outcome, right? That would be kind of political.
Well, if pure power would work, if the legal realists were right, I don't know that you need a coherent theory. What I think is the case is that to be persuasive, even in the law today, you have to have a coherent theory.
Is that a sociological?
Probably.
Let me just finish up.
Yeah.
But I think as law professors, we're trying to help our students be able to be good punsters or be able to make the mental leap of saying, wait a minute, let me try something novel in this situation to serve the interests of justice. The question is, how do you do this well?
I have no idea. I mean, that's what I'm telling you. I have no idea, because I don't, to me, when I grade, right, I'm right now writing my contract's final exam, right? And I'm putting together this mass of facts that I know that what I want my students to see, I want them to check that mental inventory of patterns. Parole evidence rule, mistake doctrine, frustration, right? Conditional promises and so on. And I want them to make the leap. I am firmly convinced that I don't know that I sat at an interview with a big firm in New York 40-something years ago at a restaurant in 30 Rock. And I remember saying something pompous and law student-like about thinking like a lawyer, and a partner at, I believe, Donovan Leisure saying to me, that's bullshit, right? That's bullshit. We think like lawyers before we get here. And the answer is, I don't know. I think what I'm testing is sort of that native ability to look into that mass of facts and see the patterns and hope that they match up to the ones that I put in. And occasionally I see one that says, whoa, I didn't think of that. Yeah, yeah. Yes?
Okay, this may be a misguided question, but I want to push you a little bit on practical applications of your theory. So here's my hypothetical. It's Groundhog Day. And you're the president of Great Lakes. And you've got an important contract to negotiate and write up. And on Groundhog Day number 1, David is your lawyer, and David hasn't read your book. David's just going to crank through standard legal reasoning like your 1Ls have done.
Right.
Okay? Now it's Groundhog Day number 2. I'm your lawyer, and I've read your book. I'm now a Lipshawite. Do I get a better contract and a better result for Great Lakes, or am I just more self-aware and humble?
I don't know. I don't know. I could actually give you, I have all sorts of ways of wiggling out of answering that question. From the Kantian to, I will tell you that my preference when I was the general counsel was to have lawyers who acted like Groundhog Day number 1. Because, again, let's not overstate the thesis. I have no issue with pure lawyering. And since I wrote the book on being a me, right, what I really wanted was somebody who would go into the room and just kick ass on reps and warranties. I hated it. I thought it was this, right? I didn't care, right? I knew that the deal didn't depend on whether the environmental rep said this or that, and there were lots of lawyers on Wall Street who cared about it and who were combative about it. So the answer is, I probably am a little bit, right? What I really want, it depends. Sometimes I really want Groundhog Day, right? But sometimes I want a lawyer who either can or has the capability of doing both. And again, to take somebody who's closely affiliated with Harvard, I'll use an example, Peter Atkins at Skadden. Peter could do both, right? Peter could do both. And if Peter didn't want to do both, he'd get somebody in the firm to do the reps and warranties. But when I had a hard call to make at Great Lakes about a board governance issue, right? Do we pull the poison pill? Do we not pull the poison pill? Do we take away the classified board? Do we not take away the classified board? I called Peter. And we had sort of a, I mean, I don't even, Peter's Peter and I'm just me, right? And that's what I wanted. So I think I wiggled out of that.
Over here? Oh, Sophie, go ahead and then over here.
Yeah. I'm gonna let you run the queue. Tell me
All
what.
right, yeah, just because I can see up either way. Go ahead, Sophie, and then over here.
Hi, thanks for a very interesting talk. And being Professor Wilkins' student and at the law school
Don't hold that against her.
where we learn how to think like a lawyer, because that's ultimately what our clients will need in the future.
I'm gonna debate, I would debate you on that, just given the last question, but okay.
How do I have to understand you? Do you have to unlearn how to think like a lawyer from the very beginning, or just not to learn to think like a lawyer at all? Or to learn how to think and then
I think what you have to do at the outset is learn how to do it. I think that part of what, again, I think that we do it well. I mean, I think that if you look around legal education, there's a kind of a consensus that the first year of law school actually works pretty well. I mean, at Stanford, which my alma mater, which is, I think, really at the cutting edge on changing the second 2 years. First year is pretty much the same. I will tell you, and it's probably obvious, when I teach contracts, I don't care about coverage very much. I don't care whether we get to assignments and delegations. I don't care whether we get to this or that. Because what really is important to me is teaching my students, right, exactly that rigorous, razor-sharp, deductive, inductive, abductive aspect of thinking like a lawyer. That's my job. Right? It's a little bit like, in Jewish tradition, you're not allowed to study the Kabbalah till you're 40 years old, otherwise you go crazy. Probably it's the case that nobody should read my book while they're a first-year student. But once you're a second-year student, it's okay. Right? So again, I am not denigrating what you're learning one iota, right? But I think that what you will find as you move on, particularly in a transactional practice, is what I said in the talk. You can be right legally and just so wrong about what meaning is transpiring. I could give you anecdotes.
So Jeff, instead of doing that, we have two questions. The last one was just from your wife. So I want to make sure we get to that because I'm actually really fascinated by first here.
So actually, going off what you were just saying about 1L year works, and I completely agree. It's a pressure cooker that I think helps you figure out that's where you learn the black holes in your 1L year. So if that's just like a piece of lawyering and we need this complement, what is that complement in the curriculum that needs to be taught in law school?
Yeah, that's so hard. I teach an upper level small class. I have 8 students called Entrepreneurship, Venture Capital, and the Law. And we spend a lot of time just talking about the difference between, we talk about the difference between the lawyerly mindset, the entrepreneurial mindset. I'm able to draw some stuff from non-legal sources. There is a professor at Virginia, Sarah Sarasvathy, who talks about effectuation reasoning versus, now I'm having a senior moment. But the distinction, the example, the thought experiment that I give to my students is, you're supposed to bake something or make something to eat, right? Are you more comfortable with finding a recipe and going out and buying the ingredients? or looking in your cupboard and seeing what you've got and deciding what it is you can make out of what you've got. Those are her examples of the two different kinds of reasoning. Lawyers tend to be, I think, I'm going to make a generalization, more comfortable with getting a recipe and filling it in. Entrepreneurs, I think, tend to say, hey, what have I got and what can I make out of it? And so we talk about that. Personally, I think that we are so bound in our curriculum and so encapsulated in Pound Hall and Wasserstein Hall. But when I say things like this, my fellow members of the faculty go, like, I don't think, we have a business school in our building, and I have suggested that we shouldn't be teaching corporate law. What we should be teaching is a course that's mixed of law students and business students, and it's the law and finance of corporations.
But are there classes specifically that would influence the thought processes
Sure.
in a way that would be complementary?
I'm not sure, again, to go back to my point to Lyle, I don't know what about this you can teach. I mean, this is diversity at work, right? It's not racial diversity, it's not ethnic diversity, but it's thinking diversity. And so it seems to me one of the ways to get there is to do, for example, what Stanford does and says, look, got this great university, law and, right? Law and. I don't know if I can teach you how to see outside of being a lawyer, but I suspect if I put you on a team with a non-law student, something's going to click. And that would be my answer, right? I would create a curriculum and use the assets of a university, like Stanford has done, to expose lawyers, law students, to people who are going to say, yeah, well, that's thinking like a lawyer, but that ain't going to solve the problem.
Last question.
I suppose I could ask you this once we get.
No, we all want to hear.
I'm not sure.
I had an analogy that sort of answered one of her questions. Is this like being an artist? You can go to art school and learn how to draw, and most great artists know how to draw. You can take instruction in drawing, but I don't think you can take instruction in how to be Picasso. But I also suspect that Picasso can draw.
Right.
He knows how to draw. He knows how to do
Father was an
he knows what the law school taught him, what the art school taught him before he is Picasso. But you can't teach him how to be Picasso.
I would like to introduce everybody to the smart member of our family. and in fact, when I was listening to your question, I didn't get, but I think athletics is the same way. That you learn things mechanically, but you have to get beyond the mechanics. And I'm trying to think, sports analogies are sort of not the thing to do anymore, but golf swings, right? There are classic ones, but there are ones that aren't classic and they work. And I think that's a similar relationship between sort of the techniques and the mechanics and getting beyond it.
Well, Jeff, I think we've seen Picasso in action here, and thank you very much for
Okay.